Number six, unauthorized employment income source. So they came out with the updated regulations for the TN NAFTA agreement. So now it's called the USMCA, MCA, MSA, or something like that. And essentially, this is the agreement, the trade agreement that U.S., Mexico, and Canada have. And within that, there's an immigration component that says certain professionals could come to the United States to work for certain employers, this and that. This is a TN visa, not the point of what I'm talking about here. But I was reading the regulation. I saw there was a part of it, and I hadn't read the original regulation in detail, so this was good recap. Essentially, they're changing up all the parts to say TN, you use USMCA or whatever NAFTA, you change the words. But there's a part where it said professionals, and section G, and then I won't go into the numbers of the section and stuff like that because that's important. But essentially, it codifies a regulation that I'm not sure if codifies only refers to statutes, but essentially it puts in the regulation, and it has been, where it specifies what it is to come in on a like a B1 and still be able to operate professional services in the United States. So I thought this was a good resource if you're ever challenged by the agency that say, "Oh, you're doing unauthorized employment." They make notes, and the big thing is, which you've always talked about in the show in the past, is where is the source of the income coming from? Is it a U.S. source or foreign source? I saved the stuff here. Let me find where it is. So it's like it says, if a person is coming here, the kind of when you're looking at the primary source of remuneration, and I think I'm pronouncing it wrong. I never got that right, but for the proposed business activity, if it's as outside the territory of the party grants a temporary part, the principal also look at the principal person's place of business and actual place of accrual of profits, at least predominantly remains outside the party's territory. A party shall by party I mean the country who's getting the visa. So this applies for immigration laws for all three countries. A party shall normally accept an oral declaration as the principal place of business and the actual place of accrual of profits. Where the party requires further proof, it shall normally consider a letter from the employer attesting to these matters sufficient proof. So there's this big emphasis of where the money is accrual of profits is happening. The source is potentially where it's from, and the place of business where it's at. So, I have a case where this guy was in the United States, and then all of a sudden he won the diversity law. He could file for. He was on a tourist visa, could file for adjustment, and he had this one-man operation working in technology. I say to keep it vague, not to reveal confidential information, and it was problematic because he was running the whole company. So on vacation here, it was a one-person operation. I said, well, if you had a business where you had employees, I'd be more comfortable filing for adjustment of status. But because all you're here, the businesses in Canada, they're Canadian clients, the money's in Canadian accounts, all there. But I'm too afraid of messing things up on a diversity visa, of them saying you're doing unauthorized employment. So I told him, do consular processing. I'm not comfortable with filing adjustment on this one. And I'm sure there'll be another lawyer that'll file adjustment, no problem, and probably get approved. But these fact patterns kind of scare me. It matched what it was here. If he had a company with employees, we could say employees are doing the full work, and maybe he's just guiding them from here. Okay, I would have been more comfortable with that, but not in this fact patterns. But here, there's some rules. The regulation in particular is 8 USC. Where did I save that law for now? 8 USC 2214.2. It's in there on the TN section, but this is focused on the TN, or now the USMCA. Is it USMCA? Let me find it. Yeah, USMCA. But by analogy, it should go into the other ones. And then when you're looking at work, I think on the work visa too, it kind of gets into this. But if it applies, that's the thing: is this only apply to USMCA or not? Or could this apply to other visa categories? I think in 214.2, 8 CFR 222, they get into this as being a general rule. But I think by analogy, it should be considered, there. I don't know. I got to do more research on this, but essentially, I'm sticking with what I thought beforehand, which is like be very cautious of these scenarios. I've seen CBP let people in when they said, "Oh, you're going to work, yeah, but the company's overseas and all that." They've been okay with this. So CBP generally has this policy. The USMCA comes in under CBP regs, and this rules and regulations update. It says Department of Homeland Security, U.S. Customs and Border Protection. But I think by analogy, it should be something that the Department of State and the USCIS should apply to. But it's all discretionary at the end of the day, so you never know what's going on, and you kind of afraid of messing it up. So you got to be careful with that. But I thought that's, if you needed to fight it, here's a place where you can find some arguments, and it can be helpful.